So thank you so much, Prajal Sir, joining RESO platform. And it is once again a possibility and opportunity for us to have you on this platform. You're joining from England, Lincoln University and Department of Law, and you're working as a senior lecturer there. And you've written good number of research papers and articles along with your book also, which outstands. And we're very much glad to have you, and we would certainly uh, hear about your introduction, your work, and all those things. But I just would like to include my first question also with that. So, but before that, I would request you give us a little introduction of yours, your work, and all, so that we can finally pitch into the questions.
Thank you so much, Surinder, for having me, and Riso. What a fantastic platform for researchers in Southeast Asia and the world across. You're doing such a fantastic job. Having looked at your past podcasts, I think it does throw a lot of light on the research aspect of Indian academics, practice, and trying for academics and practice to go hand in hand. So, my name is Dr. Prajal Shah. I'm like you said, a senior lecturer at the University of Lincoln in England. And my research areas are police investigation, suspects' rights. I look into sort of all the aspects of policing, police powers, and the human rights surrounding the suspects' rights. And when it comes to the suspects interviewing, investigation, what are the things that can actually what are the trends that have been developing over the past few years? And I've done a comparative work in my book that came out in 2021 on the police investigation aspect and the impact it has at a pre-custodial stage on a suspect. What are the things that we can look at, for example, safeguards to try and ensure how we can facilitate a more fair, impartial, and a very open-ended interview when it does come to police investigation. For my book, I had interviewed around 25 police officers from 2012 to 2016 from a variety of roles and from a variety of states in India as well. So I just thought of getting the practical perspective. So, through academics, of course, we are aware the media is quite well known for highlighting all the issues that are surrounding the legislation, the law in theory to the law in practice. But I thought it's best to hear from those practitioners, for example, those police officers, and also certain lawyers, public prosecutors, defense lawyers, and I think I also spoke to two of the retired judges, trying to just ascertain what is basically the issue, what are the things that actually go right or wrong during an investigation. And I thought it would be a good idea to try and provide a comparative perspective with England and Wales, only because before the introduction of the Police and Criminal Evidence Act, famously known as PACE, that came into England and Wales, a lot of the situation when it came to evidentiary matters, when it came to police investigation, a lot of those issues were actually what stand even now. I mean, it's 2024, but a lot of police investigation issues that stand in India in a variety of states, they existed back then. And quite a lot of similarities exist, which we think, well, we might be able to draw quite a lot of inferences, some lessons from England and Wales. We can learn from their system what has worked for their system, and maybe even try and implement those aspects into the Indian system when it comes to the policy, practice, legislation. Yes, there are cultural differences. They're always going to exist. They're going to coexist. But we need for them to coexist and do so amicably. So, in a nutshell, all of that is my research. So hopefully, I'll try and talk about those aspects. I'll also try and talk about a chapter that I've just written and the project I'm working on with. It's a cost project and it's called Implemendes. I'm working with Professor Dave Walsh at the moment, who's a professor at the University of De Montfort, and we're working basically to implement quite a lot of the safeguards. They're known as the Mendes principles, so trying to introduce them into an effective police investigation.
Okay,
so that is all about me.
Thanks a lot giving your comprehensive introduction about your research work, about your contacts that you've interviewed police personals, officers, and should have figured out data. It may be quantitative data and qualitative data, and your work and your book also. It's an authentic work understanding and learning judicial system and police investigation system, it is important, and how does it have implementable possibilities in our context. That is also one striking feature which I figure out. So I would like to pitch on to my formal first question. It says, like, can you give us a brief overview on police investigation in India?
The police investigation in India, of course, starts off with the very basic proceeding to the spot, ascertaining the facts and circumstances, depending on what the physical aspect of things are. So when a police officer is actually looking into and can find details, etc. Alternatively, you can also sort of include details such as a report made by either a victim, a witness, and depending on those factors, the police officer may then decide to go into the investigation of it. In India, of course, as you know, we have what is sort of, in the Indian Evidence Act and the Criminal Procedure Code, which is now replaced, but there are these amendments that are going to be carried out. And we've got cognizable and non-cognizable offences. So cognizable offences are typically those offences, as you know, they are where the police officer can arrest without a warrant. For example, these are these really high-profile, quote-unquote, as quoted by police officers, high-profile cases such as murder, rape, dowry debts. So all of these come under cognizable offences. And then you've got non-cognizable offences, offences such as assault, defamation, theft, and all the other offences defined under Section 2.1 of the Code. This is where a police officer does not require an arrest warrant, and therefore they can arrest, they can detain, they can question without an arrest warrant. Now, all this information is then taken to the police station, and it is given to the investigating police officer, and these all must be in writing, and they're famously to be sort of noted under the first information report, an FIR, which is quite notoriously gained quite a lot of momentum over the past few years. A long time ago, it was quite barbaric. A lot of our laws are quite colonial. A lot of Indian laws have been sort of alleged by a lot of academics who said that all the laws are quite barbaric, having this very notorious colonial past, which is why we need this this change. We need this reform, and I think all the academics, practitioners, judges, law commission reports, and we've had about 10 of the fantastic law commission reports that do talk about it, that we need to replace these. And I mean, as a result of all of these, the FIR now needs to be on a written basis. So all of the information must be recorded and is contained in writing in the FIR, which is read, confirmed and signed by the person who's called the informant, so who comes ahead and brings all of this information towards them. And this information, this FIR, of course, is also sent to the magistrate, because the police officers have these wide powers of either investigating, depending on whether they deem that this is a serious matter, there's an offence committed of a serious nature, in which case they go ahead and they investigate. But if there are those offences that they deem not so serious, they will not go ahead and investigate. And therefore, all of these need to go to the magistrate, who will look into and who will also look into why the police officer has not actually proceeded towards that investigation. Once the suspect is at the police station, they must be made aware of their constitutional right. As you're aware, we've got a fantastic written constitution in India, which makes it quite good, which makes things quite coherent. It's academically quite good as well. So under Article 22, they must be informed of all of their rights. The police officer must inform the suspect of all of these rights, and these need to be recorded in the statement, and there needs to be this record in the police diary as well. And the investigation must be completed within 24 hours, and then within the end of the 24 hours, and within that 24-hour window, the suspect is to be produced before a magistrate in the same sort of jurisdiction. If for any reason the investigation goes beyond the 24 hours, then the officer in charge of the police station within the jurisdiction, or the investigating officer not below the rank of a sub-inspector, forwards the accused to be remanded before the magistrate. and this then goes into the judicial custody. The magistrates do try and avoid leaving the suspects for more than that 24-hour period, and also, and they may remain in the judicial custody for a period not extending 15 days. Now, this has changed, which I think we will talk about later. And of course, the magistrate has to look into this case, and if there is any information that is given to the police officer, has to be confirmed at with the magistrate as well. Now, if for any reason the suspect decides to confess, and as I'm sure every criminal lawyer in the country is aware, every academic is aware, any confession given to a police officer at the police station is completely inadmissible under the Indian Evidence Act. Along with Kenya, India is the only country where we do not have, where there's this almost like an idiosyncratic ban on confessions. The slight catch is, and this is what I found out when I was doing the interview with police officers, and when I asked them, are you aware that, this confession is inadmissible? I think I had about 7 out of 25 police officers say to me, yes, we are aware, but the suspect doesn't know of this, and therefore we do still go ahead with this. So there's still this culture of obtaining a confession. The police officers do investigate with a view of getting confession, which is the same in England and Wales as well. But clearly, there is certain information that can be taken from that confession, and if it is leading information, then that may be relied on. So hence, there's a slight caveat, slight catch of why, even though we've got this idiosyncratic ban, there is still this aim of obtaining a confession. And all of this is recorded, and of course it is then, like I said, sent to the magistrate. One of the main safeguards, one of the few safeguards that is included under Article 22 of the Constitution, of course, is letting the relatives know of their whereabouts, having a lawyer present during their investigation, and then having a friend informed, and basically checking on their health.
Thanks a lot, Pranjal Saab. I mean, you've spoken really great details. You've talked about cognizable offense, non-cognizable offense, and then in Indian Constitution and our procedural system, how our police functions, and at the same time, the serious crime genetic possibilities, and it's important for us to learn. And it's a group. It is really a comprehensive body of data for our audience specifically to learn and listen to what you say. It's a great and deep insight. And now I would like to move on to my second question, which is, can you give us an overview of police investigation? Again, we are talking police investigation in England and Wales, but a different context.
Police investigation in England is formulated now with like I said, the Police and Criminal Evidence Act 1984. Pre-1984, there were a significant amount of miscarriages. The very famous cases that were the foundation of this particular legislation were the Cardiff 3, you had the Guildford 4, you had the Birmingham 6. So all of these cases, what they highlighted was the need for an effective police investigation in all aspects, right from training, so giving police officers training on aspects of reminding and retaining the suspects' rights, ensuring that the police officers do inform the suspects of their rights, and also ensuring that they're met. Right from that to under the Police and Criminal Evidence Act also has, over the period of time, incorporated quite a lot of codes. So there are 6 codes now, and every code that was incorporated right from 1984 up until now, they are amended, they are changed, so they do keep up with the times. And all of these codes and all of this entire legislation, it goes hand in hand with another legislation, such as the Criminal Justice and Public Order Act 1994, famously known as the CJPO in England and Wales. So obviously in England and Wales, there are a lot of these provisions, safeguards that are met, and over the period of years, they do work out. So obviously, as soon as the police arrests a suspect, that is where they read them their rights. This is where they read a caution under the CJPO, and this caution is quite coherently worded. Again, it has changed over the period of time. It used to be quite a heavy caution. A lot of police officers were alleged to have read this caution in a very quick manner, Sometimes they would have just missed out on certain words. They could have missed out on a variety of aspects. Sometimes they would have not read their caution entirely. So these are the things that have changed over the number of years. What is the impact in case of this caution not being read? Of course, if a caution is not being read, this also means that the suspects don't have knowledge of their rights. As you're aware, the caution reads, and there are a number of elements in the caution that do inform the suspect of their right. The first and foremost right is, of course, that they have the right to silence, so they do not have to say anything in the absence of a solicitor present. And if they cannot afford a solicitor, one will be provided to them when they're at the police station. So right from when they're arrested, when they're sitting in the police car, to the point that they actually go to the police station, the suspect actually does not have to speak, does not have to divulge any information to the police officers. I mean, again, practically, not saying that this has not happened in the number of years, it has happened where the suspect has managed to divulge information, or the police officer and the suspect were just having a casual conversation, quote unquote, and divulged certain information. However, over the number of years, this has changed, and as a result of this, the judges have decided, the courts have decided, that there is a discretionary exclusion power that the judges will have under Section 76 of PACE, where if the judges deem that any confession, any information was obtained as a result of either not observing safeguards or duress or coercion, then that part of the confession or that part of the information will be completely excluded. So there is this slight discretionary power there. The second most important safeguard is, of course, the right to have a solicitor present throughout the interview. This has again changed over the years. Initially, it was quite a wide discretionary power that the police officers had, where they would deem fit, and they would ask the solicitor to either step out of the room for certain questioning, or they could try and withhold the number of hours that the solicitor would have with the suspects. So this was quite a discretionary wide power. What the police officers deemed fit and reasonable. So again, trying to push everything in that reasonability quotient. Again, the third and the most final safeguard, I would say, again, this has changed, is the tape recording of the entire police investigation. So it is important that now most all of the police investigations are tape recorded. There are some of them, if there are some of those serious crimes, they will be video recorded as well, trying to ascertain and gauge things such as looking at the scientific evidences and aspects such as body language of the suspect, the behavior, the demeanor of the suspect, and how things proceed in that manner. And then, of course, if whatever is written, there has to be a written notification provided to the suspect. And if the suspect if there are charges that are finalized, if the police officers, the investigating police officer, the custody officer deems fit, they may file certain charges, and if they do, obviously they are told to them. And the other aspect I think that is most important is the caution is given not just at the arrest stage and the search stage, it is also given just prior to the investigation stage. So it is they are trying to make it more and more fair, more and more coherent. Of course, a lot of lessons are learned even by police officers, where they've now realized that if they because they're working so hard to getting that evidence, to get that confession, the information, that they're trying to keep things in a way that by missing out maybe an important element, they don't risk losing the entire evidentiary value of maybe the confession, information, and then at the trial stage, trying not to look bad on their service records.
It's quite a comprehensive structure, police investigation and procedure, and a lot of disparities and a lot of changes we've heard, and it's a new body of data for us and for our audience also, for me also, quite a great update. So thank you so much, Prajal sir, updating us on these informations. Now I would like to move on to my third question, and it says what is the importance of legal assistance amongst other safeguards during a police investigation?
I think I'll start with the very famous case. I mean, yes, I've talked about the Constitution. We've got the written Constitution. We've got that. We've got this mention in the Constitution that no suspect shall be denied legal representation or the right to a lawyer if they do ask for one. So this is very specifically worded in the written Constitution, and it is specific. It forms a part of the basic. Part of the Constitution, so it cannot be amended, it cannot be sort of removed. And whilst it's a fantastic thing on paper, in practice, we're not actually seeing this take effect or seeing this actually go anywhere. So it isn't something that is, taking form, taking a good format. We're not getting anywhere. So right from DK Basu, the fantastic, famous case of DK Basu, where we had this highlight again of having a solicitor lawyer present during the police investigation, and that the suspect must get this advice from the lawyer before actually saying anything, giving any evidence. So we've had this in DK Basu, we've had this in a sort of there's a time scale. It was in the Iberia Commission, it was in the Padmanabhiya Commission in 2000, 2003 Malamuth Committee, the fantastic 2005 Police Act drafting committee also talked about this, and then the Supreme Court came up with the most coherent and a fantastic thing in 2006, in their directions in the Prakash Singh and Union of India case. And so this was followed by the Varma Committee in 2013, and even the 2015 Police Act Draft Committee. They've all talked about this. So there's almost like this single thread running where everyone's saying, yes, we need this legal assistance and we need to have a lawyer present. Now, I teach this to my students, and I say this all the time. If there is a single common thread that is running from the number of years on an aspect, something so important, something that is now being talked about as being a basic right. Even the sort of the United Nations have talked about this, and they're pressing on this aspect. So this is where the Mendes principle as well, the implement this project that we're working on. We want the United Nations wants all of their states, all of the countries, member countries, to try and highlight the importance of this. And this, of course, this is one of the biggest safeguards. I think it works both in the favour of the police and the suspect, trying to ensure this transparency, trying to ensure accountability, trying to tell the magistrate, at a trial stage as well, that they've taken all the safeguards, they've taken all the precautionary measures that they were expected to take. Therefore, the evidence that they've obtained is, free from free from any form of stress, duress, and therefore it's quite reliable. At the same time, it is also for the police it's also for the suspect trying to say that, oh well, yes, I was, and therefore that frustrating stage of having a suspect or a witness turned hostile at the trial stage can sort of be removed, and right at the stage of the trial that we have, hopefully if this is taken back, or because there's a lawyer present, then along with the other safeguards as well. I think this is the most imperative thing. The other thing that is most notoriously it is in the reputation of the police is the police are known to use force, coercion. They're known to beat up. They're known to use third degrees. They're known to use a lot of physical measures, even in 2024. Which they should not be using, and they do try and interrogate and investigate suspects just to deliver to the public that they are doing something, just to show the public that they've got this suspect in hand, and therefore they're investigating. So it starts the the ball running. But while it is done that, it is at the behest of someone, a suspect who's unaware of their rights, and how are they going to try and get out of it. So hence, I think all of this in a nutshell, along with a lot of other academics, they've talked about this, and they've highlighted that this is something that we need to look at.
Thanks a lot giving us very tremendous feedback on safeguards during a police investigation. Very important dimensions and areas you've covered, and certainly it is going to be a wonderful information body of data for our audience. And I would like to move on to my fourth question. It says, will this new system have any impact on reducing the load on the judicial system?
I think it's important to recognise that this new system, they're now I think they've extended the police custody stage from 15 days to either 30 days, 15 to 30, sorry, 30 to 45 days. So again, whilst this might be a fantastic thing, and you might think this is going to take a load off the judiciary, and this will connect to my previous point that I was making, that if we have all the safeguards met, we might actually be able to say, from the police might be able to say, we've taken all these safeguards, there are these safeguarding measures in place, and therefore most of the investigation information that we've derived from this investigation is reliable, is free from coherency, and it is something that might further the investigation. So it isn't going to say, oh, let's go to the magistrate and do the same thing over again, only because of our notorious personality, or the very famous reputation that we have that precedes that we do use force. So this might show that, listen, we've taken these safeguards, we've tape recorded this interview, and therefore all of this information that we've got is actually reliable and therefore reliant. So there is a chance that if we do follow safeguards, then maybe giving more responsibilities might further that investigation route. However, it's a double-edged sword. So giving the police wider powers of giving that police custody only means that they are going to try and retaliate, or they are going to try and get that information that they need, and that will further their investigation, rather than looking at what the suspect has to say and what's the credibility of the information that the suspect has, and whether or not that can be reliable or not. So that is something that the new legislation is looking into. There is a peril that giving the police wider powers without actually giving them effective training, without actually educating them, informing them of what the suspect's rights are and how to further those suspects' rights, we run the peril of maybe giving them far too wider powers. Again, this is happening in England and Wales as well. We are giving far too many discretionary powers. What the police officers deem reasonable, and how reasonable do they think? What they need to be mandated. I think one of the most fantastic things that have come up from these new legislations is also that police raids and seizures will have to be mandatorily videotaped, and forensic experts have to visit the crime scene of the offences within a certain set number of hours. So I think that this is, maybe these are baby steps, but we are headed towards a change, a good change. However, without providing the relevant police training, we are not going to see these being implemented. That's the biggest thing.
Detailed and qualitative and quantitative information for us, for our audience, and learned how it's going to come out, increasing the power of police, and how does it impact our society. Well, at the same time, I would just like to now quickly move on to my fifth and last question of this international interview record discussion. And it says can we learn from jurisdictions like England and Wales? Are there any drawbacks? How can we avoid these? If there are drawbacks, how can we avoid these?
Thank you. That's an excellent question. And I am a comparatist, and I strongly believe that, yes, we can learn lessons. And there are always going to be differences and similarities. There are cultural differences that are phenomenally poles apart. Yes, there is going to be a huge difference between what we are doing. But at the end of the day, when we are a country, when India is a country where we have signed these a plethora of these international instruments, and we've said that we signed the UN CAT, and we are not going to use torture, and we're going to ensure that the use of torture is minimized, is completely avoided during the police investigation. We are looking into the implementation of the human rights of the suspects. However, it's 2024, and we still have quite a huge number of custodial deaths, unexplained suicides, unexplained deaths during COVID. So all of these things, they do add up, and they do say that we are desperately in need of a reform. And we've always been in a need of reform. However, whatever little reform we have, it does not come it paired with the right level of training that we need to provide police officers, the right level of resources that we need to provide police officers. I mean, even in England and Wales, at the moment, there are significant amount of resources that a lot of police counties and the police officers, police stations, they lack. And it's all about how do we prioritize funding? How do we prioritize allocation of resources to organizations such as the police? We need to try and find that balance. So I think we need to pressurize the government. I think as academics, it's very easy to say the police are not doing their job, nobody's doing their job, there's a lot of corruption. But we are looking at sort of, the underpayment of police officers. We're not looking after the welfare. I mean, how are we ensuring that police officer welfare is met? Where there's very little mechanism in place for police officers to voice what they're going through. There is a lot of stigma attached. There's a lot of institutional racism across the board in India and in England and Wales as well. What are we looking at? I mean, we've got this regulatory body called the Independent Office of the Police Commission, which replaced the IPCC in England and Wales. We have the NHRC, and then we have the State Human Rights Commission as well. Every state has a Human Rights Commission. And we tell everybody that these are these regulatory bodies that look after, if you've got any complaint against police officers, lodge your complaints here. We will look after this. However, as it is absolutely appalling. But in 2018, I think there was a study conducted where the National Human Rights Commission, the NHRC in India, they have failed miserably, and they've done very little to actually show that accountability. So yes, whilst it is quite easy to try and say to the public that you can, lodge your complaints here, but then there's nothing actually being done about it. I think similarly, it is quite controversial, even at the IOPC here in England and Wales. There, a lot of academics have complained, and there's a lot of public outcry about there's very little regulation of these complaints of the system. So we need to, again, collectively learn from each other. We need, both the jurisdictions, India and England and Wales, they need to learn from each other, learn about, how can we actually combat, how can we conduct this? And at the end of the day, providing continuous training on these aspects is something that we need to look at and something that we need to work on. So I think that is about it from my end.
Okay.
Between India and England and Wales, and I look at the police interrogation, the importance of suspects' right, the idiosyncratic ban on confessions in India. So if we do look into providing, we can maybe change this, even though a lot of police practices are still going towards that obtaining of confessions. And at the end of the day, what can we learn from each other? Should we have a coherent legislation in place, which again, the new legislation, aims to show certain credibility that this is what they're trying to do. Have a coherent legislation in maybe one legislation and train police officers on that legislation and make it more human rights based. Make it ensure that we are, not just signatories to international conventions, but we're also doing something so that we are implementing those international conventions in the country. So I think that's the highlight. In my chapter, most recently on an international handbook as well, I've highlighted what are the discrepancies. I mean, in that chapter as well, I've highlighted that there are a lot of things that are in place, and they're brilliant. So, for example, there is this fantastic repository where you can lodge complaints. So, it's called a National E-Governance Plan. It's a pilot program for the Common Integrated Police Application. So basically, police officers can access this national database, and if there is any information on either a known suspect, they can get it there. So it's quite sort of, it's a good system, coherent system.
Right. So thanks a lot once again, Dr. Prajal Saji. Speaking at the platform of RISO, as I've already briefed you up, RISO is a platform of we try to focus research and academics, looking for its expansion and expandability, and trying to make our society a more better society for us in the times to come, for people who are coming after us. And this is for the very first time we are having an international discussion on law, and something which connects to our constitution, our judiciary, judicial system, police investigation procedure, and a first time we've had I mean, a person with dexterity and professional skills and knowledge in research papers, articles, books, lot of big quantitative and qualitative data with us, and been not just briefed up. There's been a comprehensive information flow here during this talk of little conversation with you. So we are very much happy to have you once again. Thank you so much for your inputs, for your insights, for your deeper knowledge that you've shared with us. I'm sure our audience will certainly draw some massive and major benefits by listening and sort of watching at this publication of yours. Thanks a lot.